would be disappointed. Good evening, everyone. Thank you. Thank you all for joining us this evening. I'm Jason Zarneski, the Kurland Distinguished Professor of Environmental Law and Associate Dean for Environmental Law Programs here at the Elisabeth Haub School of Law at Pace University. I'm thrilled to welcome you to the 2025 Lloyd K. Garrison Lecture on Environmental Law. Thank you, of course, to our distinguished guest lecturer, who we will introduce in a second. And I appreciate you making the trip down from up north for this event. I'd like to thank a number of people for helping us put on this event. Our Environmental Law Program Director, Assistant Director Lorraine Rubich in the back. Everybody give Lorraine a big round of applause. Program Manager Annie Olson. We always have to give them a round of applause because I certainly couldn't do my job well without them. Also thank Daniel DeRoe, our Environmental Law Fellow. And of course, our external events team. I see Renee and Rachel hiding in the back, so thank you guys as well. But most importantly, I'd like to thank our IT, cleaning, catering team, all of our facilities management. Without them, these events couldn't happen. So thank you very much. Before we begin today's lecture and introduce the speaker, I'd like to make a few announcements. First, after our speaker comes, there'll be a brief Q&A, so hold your questions. If you'd like to see past lectures, please, join us on social media for any of those. And I guess, another thing I'd like to say is it's been a pleasure and honor having my faculty position here and being Associate Dean. For those of you who don't know, I'll be the new dean of the Chicago-Kent College of Law at Illinois Tech come this summer. So this will be the last time I get to preside over the Garrison Lecture. It's been an honor to do so, and it's been an honor to help all of you as students. Two more items. Following the lecture, there'll be a reception in the tutor room. I hope you can join us for that. I'll remind you of that. And also tomorrow, at 1 p.m. in the tutor room is our annual Earth Day Jam. We'll have Professor Grenewalt on bass. Perhaps even our guest speaker today will sit in on a song or two, if I can convince him to do so. So without further ado, I will turn over the podium now to my colleague, Vice Dean Jill Gross. Jill, the floor is yours.
To move this an entire foot down because I'm more than a foot shorter. Thank you, Professor, and very soon to be Dean Zarneski, and good evening to you all. I'm Jill Gross, Vice Dean for Academic Affairs, and at this wonderful Elisabeth Haub School of Law at Pace University, and it is my pleasure to welcome you all once again to the distinguished Lloyd K. Garrison Lecture. We are very pleased to have Professor Anthony Moffa deliver the annual Garrison Lecture. I'm having trouble speaking this evening. The Lloyd K. Garrison Lecture on Environmental Law was established in 1995 in memory of Lloyd Garrison, a noted lawyer and champion of civil rights and civil liberties. Nearly 60 years ago, Lloyd Garrison and his associate Albert Butzel of Paul Weiss, Rifkin, Wharton, and Garrison won a landmark decision to preserve Storm King Mountain on the Hudson River. The victory for the Scenic Hudson Preservation Conference did more than safeguard an area of unique beauty and major historical importance. It inaugurated what today we recognize as the field of environmental law. Rooted in the 1965 Second Circuit decision in Scenic Hudson Preservation Conference versus Federal Power Commission are many bedrock concepts in environmental law. Standing in court to protect nature, citizen suit legislation, the environmental impact statement process, and the balancing of economics with the preservation of scientific beauty and historic resources. The Lloyd K. Garrison Lecture celebrates the vision, public spirit, and life of this attorney and aims to inspire all those who follow in his pursuit of the rule of law. Professor Moffa, today you are joining an impressive list of distinguished lawyers, scholars, and leaders in the field of environmental law who have presented the Garrison Lecture on pressing and novel legal issues for nearly 30 years. We look forward to hearing from you. And I will now return the podium to Professor and Dean Zarneski to continue with the proceedings. Thank you.
Now I'll move the bike up another 1.5 feet. Thank you, Dean Gross. So it's an honor and pleasure to introduce my friend who will be delivering the Lloyd K. Garrison Lecture on Environmental Law. Perhaps this is my last Garrison lecture, so I can invite a friend to deliver it as well. Professor Moffa joins us from the University of Maine School of Law. Portland, Maine, by the way, a great city. It's where I did my federal clerkship. It's a wonderful place if you haven't been there. Professor Moffa is a professor of law, and he also serves as the Associate Dean for Innovation. Professor Moffa is a prolific scholar, takes an innovative approach to addressing issues related to climate change and other critical environmental issues. He looks at unexplored statutes, common law principles, historical practice, methods, theories, as well as using a variety of areas of law to think about how we might deal with climate change. At Maine Law, he teaches a variety of environmental law courses, and he is much loved. He was Professor of the Year in both 2018 and 2021, and he oversees the Environmental and Oceans Law Certificate. Perhaps this is why you see him with his students out on the water. He has taken his innovative approaches to teaching and scholarship all over the world. He has gone to the COP conferences, and here you see him with elected officials. And I think that's Professor V maybe in the bottom left-hand corner as well. So that's wonderful to see. And he's also a very hip dude. He has a reputation for being a very cool professor. He has tried a number of hairstyles. As you can see, we're both currently rocking the middle-aged man short haircut. We both had the misfortune of at one point rocking the long hair rock style haircut. That is a sort of a late 30s I'm in crisis phenomenon for me. I don't know when he did it. But I have never rocked the frohawk, which I've been wanting to try. Perhaps I will do that during my sabbatical when I'm done being a dean eventually. So we're delighted to have you here. But he's done a lot of cool stuff in life as well. He clerked in the U.S. District Court for the District of Massachusetts. He clerked for Judge Kermit Lopez on the U.S. Court of Appeals for the First Circuit in Portland, Maine, which is, by the way, a good point for you all if you want to do a clerkship. Sometimes these clerks are in pretty cool locations. You should check it out. There's even a federal judge in the northern part of Yellowstone National Park in Mammoth as well. Professor Moffa graduated magna cum laude from the Wharton School of Business at the University of Pennsylvania, and he learned a law degree from a law school you've maybe heard about, Yale. They apparently do produce lawyers there, as well as law professors. He's also an avid music fan, and that's why we can get him to come to the Earth Day Jam tomorrow. Apparently, he serves as a guest speaker and DJ on the USM, University of Southern Maine music channel. So we look forward to hearing him play bass guitar tomorrow. I'm trying to convince him to play a little bass on Twist and Shout by the Beatles. So we'll see if we can manage that. He collaborates with us. Here he is with Professor Q. And hopefully we'll get to collaborate with him on a conference next year. So Anthony, if you could come on up here now. Now, sister. So Anthony, Professor Moffa, I'd like to present you with the 2025 Lloyd K. Garrison Award. This is for you. We'll get a picture in a second. So this medal depicts Storm King Mountain, paying homage to the landmark case won by Lloyd Garrison. And if you flip it over, it does bear your name and date. And so we look really forward to your lecture on the Back to the Future for Climate Liability. So thanks for joining us. And now we have to go to photo. So another round of applause for Professor Moffa. We look forward to your lecture. And that is the first time in my 13 years here that someone as tall as me has taken that photo. So I appreciate that.
You're welcome. It never happens to me either. All right. All right, let's get started. Thank you, Jason, and thank you to everyone here at the Elisabeth Haub School of Law for bestowing this honor on me, giving this lecture. You probably aren't aware of the many hours I spent thinking about what I was going to say tonight, but here we are. And I want to especially thank the folks, Katie Q, who's not here, and Annie, who've been sort of shuffling me around. As some of you are all of you are likely aware, getting in and out of the buildings and finding your way can be a little bit difficult. So thank you very much for that. As an elder millennial, I would be remiss not to theme this presentation in the style of our generation's favorite decade, which is the 1980s. And so I apologize ahead of time, because looking out, I recognize that for most of you, these references are going to be way too old. And then for some of you, they're going to seem a lot too current. And then for like 3 people, they're going to hit. So I apologize for that. And through the magic of PowerPoint and our imaginations and some of these overly strained metaphors, we're going to travel through time, and we're going to take a parallel journey looking at the polluter pays principle and climate liability. And we're going to go back in time, then we'll go forward in time, and we'll take a little bit return to the present, and then take a little look at the future at the end. So why are we talking about this? Well, we're talking about this Back to the Future starring Bernie Sanders, and again, strained metaphors. I know these are state climate liability statutes, and Bernie Sanders is a federal lawmaker, but you know, how could you not when he looks just like Doc Brown? So we're going to talk tonight about the so-called climate superfund laws that have been now enacted in Vermont as the first such statute, and now in New York. And so that's what is the impetus for tonight's journey through time. Where does our journey start? Our journey starts September 4th, 1965 in Chicago, Illinois, the Windy City. It was there that a leader offered a rather dire warning to his constituents about climate change. And this is what he said: "There is still time to save the world's peoples from the catastrophic consequence of pollution, but time is running out." And the person who said that wasn't President Johnson. It wasn't Martin Luther King Jr. It wasn't even the mayor of Chicago, Bill Daley. It was Frank Eichard, the president of the American Petroleum Institute. 1965, he said this. Unfortunately, in the decades that followed, the fossil fuel industry did not abide that dire warning. Instead, they did and acted and did not act in ways that were perhaps inconsistent with that warning. The New York legislature describes their actions in the following decades as unconscionable, calling their campaign of denial, deflection, and delay similar to those employed by the tobacco industry infamously, and in their legislative findings in the law that I mentioned at the very beginning of my remarks. In those legislative findings, the New York legislature went on to say that in spite of information provided by their own scientists that the continued burning of fossil fuels would have catastrophic results These companies hid the truth from the public and actively spread false information that the science of climate change was uncertain, when in fact it was beyond controversy. And that's what you see here on the slide, some of that campaign. Let's journey to a different decade and a different continent. May 26, 1972, spring in Paris. The Organization for Economic Cooperation and Development, also known as the OECD, introduces what will come to be known as the polluter pays principle for the first time. In simple terms, the polluter pays principle imposes liability on a person or entity who pollutes for the cost of controlling that pollution. In economic terms, it is about the internalization of the externality of pollution. Internalizing the cost of pollution control is the reason for this principle coming into being. And over time, the OECD recognizes that those costs of pollution control include things like preventative measures, but also, importantly for our story tonight, the costs of restoration or a combination of both. And the OECD has gone on to say that pollution fees represent an acceptable way to obtain these funds, to make polluters pay, which again, relevant to our story tonight. July 11th, 1979, the environmental decade of the 1970s is coming to a close. President Jimmy Carter is enjoying the first ring pop while jamming out to the dulcet tones of the Nax My Sharona in the White House residence. Presumably, I don't know, I wasn't there. Meanwhile, just down the street, a newfangled liability scheme is working its way through Congress to deal with toxic site cleanups. A scheme that is based in part on the polluter pays principle that we just learned about. A series of bills that would morph into what we now call superfund or CERCLA came up for debate in both the House and the Senate during the summer of 1979. Now we're in the 80s. Again, like I said, my favorite decade. September 6, 1986. Why this date? Well, a brilliant legal scholar was born on this day. Yeah, it was me. It also is the 80s, and so win-win. But more importantly, the defining features of CERCLA are coming into focus, right? Not just in Congress, but also through the courts as the first cases of superfund liability work their way through the federal court system in the 1980s. Congress is considering some amendments to tweak how the statute works. Lawyers are making a lot of money already dealing with the vast amount of litigation coming out of CERCLA's passage. Decidedly a creature of the sort of buttoned up 1980s rather than the freewheeling 70s, the liability that CERCLA imposes is strict. And in the context of cleaning up toxic sites, what that means is if you ever owned or operated a site or arranged for disposal of materials to that site, you're going to be liable, no fault. It is retroactive, meaning it reaches back all the way to the turn of the century, the beginning of the Industrial Revolution, and it is joint and several at every Superfund site. Any one of the owners, operators, or arrangers for any site where there's hazardous material that a cleanup requires liability for, they could be responsible for the whole amount. CERCLA made environmental law the hot new topic of the 1980s and early 90s in some of the largest law firms in America. And indeed, if I was giving this lecture, at least up until this point, then this probably would have been the hottest ticket in White Plains. Clearly, it's not that tonight, but I don't even know what that means anymore. So, June 4th, 14th, 1992. It's 1992. We find ourselves in Rio de Janeiro. There are parties of multiple types, and the parties that I'm concerned with are parties to a particular international convention. In this case, not the climate change convention that was at that same Earth Summit, But here, what I'm talking about is the Rio Declaration on Environment and Development. Why am I talking about that in this context? Why is it relevant to this story? Because Principle 16 of that declaration invokes the polluter pays principle on the scale of international law. It says national authorities should endeavor to promote the internalization of environmental costs and the use of economic instruments, taking into account the approach that the polluter should, in principle, bear the cost of pollution with due regard to the public interest and without distorting international trade and investment. This principle has found its way from the initial OECD reports into federal domestic environmental law in CERCLA, and now formally adopted as part of our international environmental law scheme in 1992. May 19th, 1997, Stanford University, before it was home to America's tech oligarchy, before it was cool, it was just a fancy university. And like every other fancy university, Stanford allowed titans of industry to give remarks. And this particular titan of industry, John Brown of BP, unknowingly made the case for these climate superfunds acts or climate liability more broadly when he said that the fossil fuel industry has a responsibility to act. And through their actions, they should contribute to the wider process, which is desirable and necessary. And then sort of very presciently says, BP accepts that responsibility. I'm sure those remarks probably probably will find their way into a courtroom when some of these cases are litigated. February 26, 2008. February 26, 2008, a small Native community in Alaska has banded together to literally wall their village off from the rising seas. Unfortunately, the wall is failing. So they do the next best thing, especially in America, and they sue somebody. And what makes their lawsuit different and important to our story tonight is that they seek damages. As in other areas of environmental protection, indigenous communities, indigenous wisdom leads the way, and theirs is the first in what will become 2 decades of tort litigation trying to secure funding for the costs of climate change through the tort system. Spoiler alert, these villagers do not win this lawsuit, if you're not aware of it. Right? So jumping forward, and we return, perhaps unfortunately, to the present. The climate crisis has been largely unmitigated. Considerable damage has been done. Cities and states are incurring bills that would make even the wealthiest professional athletes blush. It is costing hundreds of billions of dollars to deal with this problem. Who is picking up the tab? Well, the default answer is us, the taxpayers. And so enter our favorite heroes of the law, or at least mine, plaintiffs' attorneys. And where there is a potential large contingency fee, there is a way. And so these climate torts lawyers come in, and climate torts litigation has spread like climate intensified wildfire across the nation. More than 30 states and municipalities have brought cases following the lead of the Kivalina villagers. Sue whom, you might ask? Who are these torts lawyers targeting? Well, enter our old friend, the polluter pays principle. They are suing the fossil fuel industry as the root cause, the root source of the pollution that is leading to climate change. That is the theory behind these cases, if you want to trace them back to the polluter pays principle. As of right now, the only bills that these fossil fuel industry producers are paying are measured in the 1/6 of an hour, and they are payable to some of the most prestigious law firms in America. It's another way of saying they haven't won. None of these torts litigation, the torts cases have reached a successful verdict in terms of imposing liability. I know there are some examples that are admirable that have done some other things, but here we still haven't recovered for these costs of damages. Confronted with this landscape of these cases not advancing quickly enough and the bills for climate change damages racking up, Vermont and now New York turn back in time to the 1970s, late 70s, early 80s and say, wait a minute, but what about this idea of CERCLA liability in this context? And so they design statutes that they're calling climate superfund laws that track some of the key features, or at least allegedly track the key features of CERCLA that we mentioned before. And what I want to do here is walk through these statutes and examine whether they are in fact tracking these three keystones of CERCLA liability that I'm going to focus on: the strict nature of that liability, the retroactive nature of that liability, and the joint and several nature of that liability. And at the same time, I want to talk about why it makes sense, at least to some extent, for these statutes to trace these features of CERCLA liability here. So let's start with strict liability. And this is the language of the Vermont statute. The type of strict liability that courts have applied in CERCLA cases makes sense for climate adaptation because we were dealing with a very similar situation. An industry has imposed significant environmental externalities, and we are trying to internalize those externalities through the operation of statutory liability. If we look back even beyond that sort of initial parallel and look to the polluter pays principle and some of the foundational principles of tort law, again, there's a strong theoretical case for strict liability for the fossil fuel industry. If we think about the polluter pays principle, right, again, we have that direct parallel, but further, considering strict liability in the torts context and products, we here have a product through its distribution, sale, and use that has caused a tremendous amount of damage through climate change to our society and our planet, and the costs of that damage have to be borne by someone. When products cause damage, strict products liability allows the consumer who's injured to recover. In many ways, these statutes are designed to make that same sort of calculus, but on a society or at least a statewide scale. The Vermont and New York statutes both impose strict liability on quote unquote responsible parties. And just quoting from the Vermont statute, you can see here, it uses the words, a responsible party shall be strictly liable, right there in the front of the statute. New York's law includes a legislative finding that, quote, the program operates under a standard of strict liability. Companies are required to pay into the fund because the use of their products caused the pollution. No finding of wrongdoing is required. As with CERCLA, when fault drops out of that liability determination, something else needs to come in to define who is responsible. In the CERCLA situation, we can look to the geographic bounds of any given contaminated site. Unfortunately for us as human beings on planet Earth, the geographic bounds of the climate superfund site are non-existent. They are everywhere. And so we can't use that same limitation to decide who's liable. And New York and Vermont were not, oblivious to that fact. And so what they did, and they had some options, right? They could have discriminated on the basis of the type of fuel or the location of the fossil fuel producers' headquarters. That's not what they did. Instead, they focused on threshold metrics for the number of metric tons of carbon dioxide pollution we could attribute to each of these individual potentially responsible parties. And they set that threshold in both statutes at 1 billion metric tons of greenhouse gas emissions, which is good for us, which means we're off the hook. Unless you drove 2.5 trillion miles while you were in grade school, you can breathe a sigh of relief. Right? You are not responsible for 1 billion metric tons of greenhouse gases and therefore not liable under either of these statutes. One thing that these statutes do, though, that they have to do is convert extracted fossil fuels into historical greenhouse gas emissions. And how do they do that? Well, Vermont just borrowed EPA's work. There's an EPA calculator. There was, at least as of last week when I looked, still that EPA calculator still existed that converts various types of extracted fuels into emissions, right? And New York, trying to, I guess, impress us, wrote its own formula into the statute, which if you do the math and compare them, basically just stole from EPA's work. Either way, that is how they calculate whether or not you have reached the threshold. Is the liability strict? Yes. Is the liability retroactive? Also, yes. Both statutes look backward in time, which is the definition of a law with retroactive application. As with CERCLA, this makes a lot of sense. In CERCLA's situation, we were dealing with hazardous waste sites that had been contaminated from the beginning of the Industrial Revolution. And we were looking at the cleanup of those sites in the 1980s and forward. Much of the contamination could be attributed to activities that well predated CERCLA's passage. In order to fully fund those cleanups, Congress recognized that they needed to impose liability on the initial polluters, those people who owned the sites, who operated the sites, who arranged for disposal at the sites prior to the statute's enactment. So too do these climate liability statutes recognize that much of the greenhouse gas emissions, the fossil fuels burned that are leading to climate change, have already happened. And so because of that, these statutes look backwards. Now, there still remains the question of how far back to look. And that question is one of both policy and of science. And I want to say for a moment that science, at least as it exists today, only minimally constrains the ability of these state legislatures to write laws that looked backwards. We have good science thanks to a gentleman by the name of Richard Heed, who's done some very important climate accountability work that could track contributions to climate change that go all the way back to the mid-1800s. So they had that conceivably as an option. Instead, Vermont and New York really just determined where they were going to look back to based on policy. And we can see here, Vermont looks only back to 1995. New York, somewhat perplexingly, only covers the period 2000 to 2018. And just as an aside before I move off retroactive liability, it's important to remember where we've come from on this journey and the fact that we've established that the fossil fuel industry was hearing warnings about climate change as early as the 1960s. So if we were going to, in theory, say when they knew what they were doing was wrong is the time we should start liability, we would be counting further back, Vermont and New York, and they're not doing it that way. Other policy considerations are clearly playing in here, but we do have retroactive liability. Here, though, at joint and several liability is where we have the primary and very important difference. What these statutes do is they impose a cost recovery demand on the fossil fuel industry that is supposed to be at the same ratio to the cost of those states of dealing with climate change that the emissions attributable to that entity are to total emissions. And I apologize that I'm about to show you an equation. And if you want to avert your eyes because you're in law school and math is not your thing, I apologize again. Please do so. Right. So this is the equation that the statutes essentially enact or do using prose. The demand to the responsible party is proportional to the cost to that state of dealing with greenhouse gas emissions, essentially adaptation costs, is proportional to the party's share of greenhouse gas emissions over total greenhouse gas emissions. Now, Vermont took the approach of assigning the state treasurer with coming up with this number, the cost to the state of Vermont of greenhouse gas emissions, and they're working on that now. New York said, let's just pick a number. They picked $75 billion, right? So we don't have to worry about that anymore in New York. The other important thing here to note here is that I put a little globe by total greenhouse gas emissions to remind us that both of these statutes, in the denominator on that side of the equation, take a look at total global greenhouse gas emissions as the denominator, right? Now, why do they do that? Basically science. There is really no way to put an atmospheric bubble around New York of breathable air or of culture, despite as many New Yorkers would prefer, right? We can't do that. And so we can't measure the amount of greenhouse gas emissions just in New York. All we know is global. It's the only way that we can make this work. And so that's sort of a practical limitation. Given that sort of significant difference that I've mentioned now twice, the lack of a geographic bound, you might say that the way that these statutes function and the lack of joint and several liability is that they do a couple things. One is they look a whole lot more like a little known and sort of much hated form of liability called market share liability, right? Which does exactly what it sounds like. It imposes liability for product injuries based on the share of the market that an individual defendant controls, right? So this looks a lot more like that, and you can all see why that's the case. But the other thing that it does, that it looks like, is it looks a lot more like one part of CERCLA that we haven't talked about, which is a tax that CERCLA imposed, an excise tax that CERCLA imposed on the petrochemical industries. And that tax was used to fund what we now call, or what we have called for many years, the superfund. And that superfund was for EPA to use to clean up sites where it could not fully recover the costs from other defendants. And why tax the petrochemical industry to fund that superfund? The answer is quite simple. It's a recognition that those industries that were subject to the tax produce products just like fossil fuels in the greenhouse gas context that led to the contamination that is making the cleanups cost millions, if not billions of dollars, right? There's sort of diffuse and pervasive contamination by those particular industries. And same thing could be said for the burning of fossil fuels. Another way to think about this is if we think about the adaptation projects and the country as sort of one big orphan Superfund site. And how do we pay for the cleanup of orphan Superfund sites? Well, in Superfund, we went to the tax that we imposed upon the petrochemical industry. Well, it seems like we're doing something quite similar here with the liability imposed on fossil fuels. As I mentioned earlier, New York has and Vermont had the project of converting the extracted amounts into CO2 equivalent emissions. This is how they did that. This is that equation. All right, now we're going to take a journey into the future. And where we're going, we do, in fact, need roads, and roads where we can drive our electric vehicles without fear of them flooding under the tide of rising seas. And somebody has to pay for those roads. Looking ahead, Massachusetts, Maryland, California, New Jersey, Maine are all on the verge of passing similar climate superfund legislation. And unsurprisingly, the fossil fuel producers who now face liability under these statutes are upset about it. And they are challenging these statutes in federal court. And eventually those cases are going to work their way up to the United States Supreme Court. And what I want to do on this little peek into the future is try to figure out how that might play out. And so here I want to point us to, importantly, the early work of a professor named Rachel Rothschild, who presently sort of anticipated these legal arguments against the laws and authored some years ago, before the existence of these laws even came into being, a memo suggesting where those attacks might come from. And a lot of what she predicted is exactly what's happening now. And as for her analysis, I agree with her. That analysis and developments since have convinced me of this, that the statutes we're talking about that impose climate superfund liability are likely not preempted by the Clean Air Act and its regulation of emissions. And I say that because of a couple of things. First, these statutes don't purport to regulate emissions at all. They purport to impose liability. And second, even if we are doing the tort professor thing and saying, well, imposing liability is deterrence and therefore it's regulation of emissions, it's unclear at this point whether the United States Supreme Court and the EPA believe they have authority to regulate greenhouse gas emissions. West Virginia versus EPA suggests maybe not. The Supreme Court doesn't think so. And EPA right now is reconsidering the endangerment findings. So maybe they don't think so either. So I struggle with the idea that there's preemption by the Clean Air Act here. I also agree with her analysis on the question of personal jurisdiction. And again, I apologize for any of you who don't want to revisit civil procedure and the idea of minimum contacts. But there's significant Supreme Court precedent, a case called Ford Motor Company versus Montana, where the Supreme Court said that as long as a party's in-state activities relate to the alleged harm, that is enough for a state's jurisdiction to reach that entity. And all of these potential fossil fuel defendants in these cases have activity within the states of Vermont and New York that relate to the production and use of fossil fuels. So I think we're safe there. However, when it comes to the other claims, I'm a little bit more pessimistic, because to use a term that by 2031 will surely be outdated, they are giving unconstitutional. And why are they giving unconstitutional? Here's why. It's sort of a morass of four things that I think not one of them alone is very compelling, but all four of them together have this sort of impetus that our current Supreme Court in its current makeup will find attractive. Or put another way, I could see a cobbling together of justices based on different justifications, concluding that these statutes are unconstitutional or at least impermissible. What are those sort of morass of claims? First, federalism on sort of two dimensions here. Separation of powers between states and the federal government, and states regulating one another. Those are the two dimensions that are, I think, going to resonate with some justices here. On the first, national and international pollution, transboundary pollution, sounds like a matter of federal policy. And that's going to resonate, I suspect, with some justices. On the second, Supreme Court precedent from the Clean Water Act suggests that it's the source's state law that applies when you're dealing with interstate cross-boundary pollution. Well, that gets complicated really fast in this climate liability situation, where not every state has a climate liability statute like the ones we're talking about here. And so I have concerns there. The due process clause of the 14th Amendment there's a retroactively imposing harsh penalties is something that the 14th Amendment is not too favorable on, and looks at whether those penalties or fees are quote unquote arbitrary and irrational. And those are the kind of flexible words that allow for a lot of argumentation. And the amount of liability that's threatening these companies right now is so significant that I could see a compelling argument made to at least some justices that these bills that are being sent by administrators in Vermont and New York to fossil fuel producers are in some sense arbitrary, or at least too large to be rational from their perspective. The Dormant Commerce Clause. Dormant Commerce Clause is all about burdens on interstate commerce that states impose through their laws. There is some question after a case called National Pork Producers whether non-discriminatory state laws like these climate liability statutes could be invalidated at all under the Dormant Commerce Clause. There are at least a few justices who think so. And if those justices will evaluate whether if they believe that the Dormant Commerce Clause applies to these non-discriminatory state laws, they'll weigh whether, in their view, the burden on interstate commerce that these laws impose outweighs the benefits that they provide. And that is, again, a very squishy and flexible standard. Indeed, the fact that it's so flexible is why some justices are reluctant to recognize that we can apply the Dormant Commerce Clause to non-discriminatory state laws, including Justice Gorsuch and to some extent Justice Barrett. That leaves me with the last one, excessive fines. The Eighth Amendment says we can't impose excessive fines. And as a torts professor, I feel compelled to mention BMW versus Gore in this context, and punitive damages, and how these statutory liability schemes at the state level have that same flavor. Again, like I said, I don't think any one of these claims is all that compelling on its own. It's the combination of the four and the fact that you can pick one or two justices here and there that I worry for the constitutional fate of these state laws. Well, that's a pretty depressing way to end, so I'm not going to end that way. And I'm going to say this. And this is the point that I made in the article that was on the slide and sort of what inspired this talk for me, which was really about doing this not at the state level, but at the federal level. And if we impose this kind of CERCLA-esque liability at the federal level, that avoids many of these constitutional problems. Now, why the hell would the federal government in its current constitution do that? Well, maybe we can make a deal, right? Maybe we can make a deal. And here's why. Right now, as we sit here tonight, there is still leverage. The leverage comes from two things. One, the 30 some odd torts cases that sit unresolved in state courts that threaten to impose significant liability on these producers. And two, the superfund bills that I'm talking about this evening that are still on the books, that are still good law, that there will be bills sent to fossil fuel producers pursuant to in the next 3 to 5 years. Until those laws are invalidated, until those tort suits go away, these fossil fuel companies have to deal with this litigation. They have to deal with the possibility of being liable. And so that is a bargaining chip. If we can make all of that go away, if they agree to some amount of liability, we might be able to meet somewhere in the middle. Now, I'm not saying that that is necessarily going to happen, but it seems like it might be our only hope at this point from where I sit in my analysis of these cases. So, sort of wrapping us up, 40 minutes ago, we went on this excellent adventure, Vermont, New York, the 60s, 70s, 80s, 90s, today. And we learned from these two great states that are dedicated to one proposition. And that proposition is be excellent to each other. And if you're not, you should pay for it. Thank you. Yeah, I was supposed to. Sorry, that was a lot. Sorry, I talked for a while there.
Please raise your hand. We may have some microphones, so any questions for Professor Moffa.
If you want right here.
Stand up and introduce yourself and ask your question.
Good evening, everyone. It was an excellent retroactive. It was a treat for me. My specific question is, you mentioned how the state superfund acts sort of mirrors CERCLA, and inspired by CERCLA. You mentioned how CERCLA is essentially taxing, the word taxing. Yeah. And during my research, I felt like, and even reading the three lawsuits which are filed, they're more basing the State Superfund Act more to be a non-tax rather than a tax, and the testing under Dormant Commerce Clause becomes completely, historically has been quite different, with the Pike test not applying for taxes. Yeah. So in your opinion, would you classify the State Superfund Acts as a tax or a non-tax act? Thank you.
I thank you for the question. I would not classify them as a tax because they don't themselves classify themselves as taxes, and they don't purport to be taxes. And one of the reasons I say that is that there was at one point a federal statute that got nowhere that had a similar type of scheme, but was much more explicitly a tax. And I talk about this in my paper. These they're not quite taxes, right? Because they don't have the same kind of uniform formula that taxes have, and they purport to impose liability in a somewhat different way, and the way that that the liability is extracted, the process that comes from that is a little bit different than the process that would come from a tax, right? They're sent a administrative order, just and asked to pay for liability, but then there's a court process they can follow to challenge that liability. I don't quite see it as a tax. I do think it's interesting that it seems like it was a strategic decision in the two cases that you're mentioning for the opponents of these statutes not to paint them as a tax either, right? For some of the reasons I mentioned, I think it does, and you're mentioning, I think it does benefit them to leave them as something different, retroactive penalties in their eyes. Oh.
Thank you. Hi, thank you so much for this lecture. I love the Back to the Future background. I want to steal it from you. So you mentioned that there's potentially some leverage here, and you talked about the enacted laws, but also climate towards litigation that's ongoing. Yeah. And I'm curious, based on your analysis of the laws potentially being overturned by the Supreme Court, if you think that really provides the kind of leverage necessary for this type of a federal level law. And if not, do you have more hope from the ongoing climate towards litigation, and why? Okay, so that's a great question. So one, to answer your second question first, I do have hope for the climate towards litigation, if for no other reason than the Supreme Court recently denied cert in the Hawaii case, and there are discrete common law suits in many jurisdictions. So only one of them has to hit for it to be potentially catastrophic for the fossil fuel industry. And so unless they're all wiped away by something like a statutory immunity that doesn't come with this kind of a deal, then I think there's still danger there. On the sort of my reading the tea leaves on where the Supreme Court's going to be in 5 or 6 years, right? That is just what it sounds like, me reading the tea leaves, right? I'm just guessing, just like their lawyers are probably guessing, right? What I'm saying is, if I were going to bet on it, I would probably bet with the current makeup of the Supreme Court that these laws are going to be struck down, right? I don't think that's that controversial of a statement or that crazy of a statement, but that's still, I think it's very close. And I think that the fact that it's very close means there's a chance that they won't be struck down. And the fact that there's a chance they won't be struck down means that there's room to make a deal, right? As long as that's the case. What worries me more, honestly, standing here tonight, is that what I have heard rumors of is talking in backrooms in DC about federal statutes that would try to do away with all of this in one fell swoop. Right? Forget about going through the courts, forget about making a deal, let's just get rid of it all, right? And if they do that, then obviously none of this matters, right? And so I see this as a moment in time where there's still leverage, and I think it would be remiss of folks who believe that the polluter pays principle means that these companies should pay for some of the costs of climate adaptation, because otherwise we are going to pay for it, should take advantage of the opportunity we have to use the leverage that we do have right now. That's what I'm saying.
As a quick follow-up, the federal is going to introduce that for both.
Yeah, and I will say it's not, I haven't seen anything formal in that respect. So I won't try to guess what they're gonna do. I know that when I wrote the paper, 2 years ago, it was a project among some lobbyists in Washington. And so it has to be a project again, given the current makeup of the administration and the courts in DC right now.
Time for a final question.
Thank you. Thank you for the lecture. Sorry, I'm going to read off my phone. If the demand is made to these responsible parties and it's proportional to their share of total greenhouse gas emissions, then setting the timeline or the look back period from around the year 2000 up to present, it would mean that historic polluters are really left off the hook comparatively, right?
Yeah, I mean, so great question. The historic pollution, that basically, where the biggest chunk of it that's being left off the table that your question presupposes is probably, this is just me in broad strokes, 70s through 90s, right? That's where you have and really in particularly like the mid 80s through the late 90s is a pretty significant chunk of global emissions that have led to climate change that New York is consciously saying we're not going to impose liability for. So is Vermont, frankly, because they're starting at 1995. And like I said, that has to be a policy determination that these legislators are making, because there's the science, and if we're looking at the polluter pays principle, the theory suggests we could go back further if we wanted to. So they had to be made. There's some kind of a reasoning there, which I don't have the full answer for, and I don't want to guess at.
Thank you very much.
Yeah, thank you.
So again, please join us in the tutor room for a reception. This is a really exciting lecture. As a young Gen Xer, I'm surprised you referenced the 80s when you probably don't remember it. When I saw Back to the Future actually in the theaters, it was lovely. Also, your toggle from 85 to 89 for Bill and Ted's Excellent Adventure was an interesting choice. We can debate the merits of later. But clearly, well thought out, excellent presentation. Everybody loved the slides. Please join us for the reception, and thank you all again for coming.